All right. Well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office, and our topic today is actually about planning to pay for care, how to afford paying for care. Speaking of long-term care in particular, not just like hospital stays, things like that. So particularly what we're looking to talk about is, with long-term care, nursing homes, assisted living facilities, that type of long-term care. It can be very expensive, right? And people are worried about how they can afford to pay for that, or what they can do to help plan for that, because it's often something that people are not looking forward to having to pay for, and it's a big concern of a lot of people. So I'm going to walk through some of the ways to, some of the ways what we would primarily work with someone on paying for that care, and things you can do while you're able to plan in advance, at least to help with that process. So a couple things before I dive in too deep. Just know that you can submit questions through the Q&A function, and I'll look over periodically, and if I see them pop up, I'll answer them as they come up. So feel free to do that if any questions come up. And then at the end of this presentation, you'll actually get an email with a couple of things attached to it. So there's actually some handouts that we have. One is our sort of a diagram of a home, and it's different ways to plan for like protecting the home from long-term care if people are worried about that. And then also our long-term care pyramid and the different goals behind long-term care planning outside of just protecting things, but also why somebody would want in particular to do this planning. So you'll get some of those. And then also part of that email will be a feedback form, which will give you a place to reach out to us. And if you fill out that form, it'll say that, you want to sign up for an initial consultation, and those initial consultations, are complimentary, and they are usually scheduled for about 2 hours. So it doesn't cost you to come in and talk to us about your concerns. Especially if anything we talk about today raises any concerns, I would really recommend setting up that initial consultation. I think it could be very helpful for you. So you'll receive that at the end. But to get started, again, long-term care planning is specifically, when we're talking about that, we're not just talking about like a long-term disability so much as like, somebody who is unable to work because of that disability. It's really more about, when someone gets older, or if they have health concerns that puts them into like an assisted living facility long-term, or a skilled nursing facility long-term. That's what we're really talking about with long-term care. It can also cover at-home care too. I don't go into as much detail on that generally because it's not as frequent that comes up as a long-term strategy, but it is an option. So with long-term care planning, I mean, the biggest concern people have is definitely cost, right? To give you sort of a general idea of what the breakdown on cost would be, and this obviously is going to range depending on the level of care someone needs, the facilities that you're going to. It may vary area to area, but a general idea of breakdown of cost is it usually ranges from least expensive to most expensive. At-home care, which can be the least expensive, but it can also be the most expensive because they tend to charge hourly for that level of care. The organizations that come into the home and provide care. So you can imagine how that could be, depending on the amount of care per day and per week that someone actually needs, how expensive that could be based off of that. And, I'd say an average hourly rate I see for that, or hear people talk about for that, is in the neighborhood of, $25, $30 an hour, something like that. It may be higher now, in particular with people being in demand as a workforce. So, $25 to $30 an hour, though, if you extrapolate that out over a long period of time, it can be very expensive, more expensive if you need round the clock care, more expensive than a skilled nursing facility even. Then the next kind of intermediate step would be, assisted living. So when people are talking about an assisted living facility, that's where somebody needs some level of assistance, but they're not in the highest level of care, right? They may have, memory care concerns, that may be just mobility concerns, but maybe they're not at the highest level of care. So that's where a lot of people would start if they're moving into a facility like that. It would be assisted living rather than going directly to skilled nursing. Although, again, depending on someone's health, that can vary. For cost for assisted living, there's a pretty big range on that. A low end, where someone's, needs a little bit of assistance, but not maybe the most, would be probably in the neighborhood of $5,000 a month or so. I mean, I've seen lower than that. It's less common these days, but it's something that you can anticipate usually being about that much at least. And that's in our area here in Wisconsin. That's not like a national average. That level or cost of care can actually go up to closer to $8,000 a month if somebody has memory care concerns. So that's where we're talking about like Alzheimer's diagnosis, some form of dementia, right? Something like that, where they need a lot more assistance related to that type of concern. So that could still be at an assisted living facility, but it is usually in the neighborhood of $7,000 to $8,000 a month. Is not unheard of for that. Skilled nursing, like I said, tends to be the most expensive. Skilled nursing would be, you really need the most assistance of anybody. In a long-term care setting, you need someone there around the clock, potentially, or a nurse always on staff. Usually people are in skilled nursing not for more than a couple years at most, because that's just how where their health is at. Assisted living, you may see someone there for quite a while, actually, especially depending on their physical health. But skilled nursing, that's when you're getting closer to maybe anywhere from $8,000 to $10,000 a month. I've seen 9 as a pretty standard average for that for a lot of people. So if you do the math, what that would cost somebody per year, that's obviously a lot of money, right? And not many of us in retirement have the retirement income alone to cover that out of pocket without dipping into our own assets. And that's where people are really concerned when you hear someone say, I don't want the nursing home to take my home, or I don't want the nursing home to take my assets. It's not so much that the nursing home is taking those assets from the individual. They don't force them to turn them over the moment you go in. It's just that they're paying so much for their care that eventually it eats up a lot of their assets. So that's where we look into, how do we pay for care, right? And so one of the first things I can recommend for somebody, if they haven't done this already, is to look into long-term care insurance. Again, this is different than long-term disability insurance. So you're not going to pay Aflac for your long-term care insurance. That's like if you can't work, right? So long-term care insurance is specifically geared towards paying for at-home care, assisted living care, or skilled nursing facility care. What we're talking about with that is it'll usually pay for 3 to 5 years, somewhere in that neighborhood. I've seen them pay indefinitely, but you don't tend to see policies like that anymore. The ideal time to look at long-term care insurance is usually in your mid to later 50s, or into your 60s. Once you start to get above the mid to later 60s, you're looking at it being more expensive, right? It doesn't generally cost you anything to get a quote on it. So you need to make the independent determination for your what your cost of that insurance is going to be. Don't listen to like your neighbor of saying it's expensive for them. There's a couple of reasons for that. One, everybody's definition of too expensive is going to be different, right? Too expensive is often based off of personal preference or what you can actually afford, right? But it's also when you're talking to somebody of what their cost is. If it costs Jerry down the street this much money to actually get long-term care insurance, well, they're being based off of their age, their health, their situation. So get a quote on it yourself would be a good thing to look into. And yeah, like I said, 3 to 5 years of coverage through that is pretty standard and is very helpful. The reason long-term care insurance is so important is because if you have those couple of years covered at least, you are able to pick where you can receive care a lot more freely than you would if you were stuck with just Medicaid alone. A lot of facilities these days are starting to require a certain number of years that they receive payment from the individual before they let them stay there on Medicaid. So that long-term care insurance is very helpful to cover that because it's money that you don't have to dip into your own assets to pay out of, right? That's what the policy is there for. But it also usually covers enough time to pay for a couple years of care. So when we're talking about what happens if I don't have long-term care insurance, right? What other options do I have? So if you don't have long-term care insurance, that's where we start to look at some programs through the government to help pay for care. And a big misconception people have is they think, well, I have Medicare, right? So Medicare only covers rehabilitative stays in a assisted living or skilled nursing facility. And even at that rate, it's only for about 100 days. And they don't cover the full value of those 100 days either. So it's not an indefinite thing. Once those 100 days are up, or possibly sooner, if they determine that they're going to try to withhold those benefits going forward because they know you're going to stay there indefinitely. One of the issues you're going to run into then is, well, how do I pay now, right? If Medicare doesn't cover this anymore, that's when you're dipping into your own personal assets if you also don't have long-term care insurance. Medicaid is the program that will pay for an extended stay at a long-term care facility. Which in order to qualify for Medicaid, you have to be below a certain amount of assets and your care has to be more expensive than your income. So you can't just pay out of pocket or be able to pay out of pocket, because if you were able to do that, you wouldn't need Medicaid. So in order to qualify for Medicaid, though, that's where the asset limitation starts to come in. So this is really where people are talking about, I don't want to lose my home to the nursing home. I don't want to lose my assets. They're usually spending through that until they can get down to Medicaid levels. How much you can keep, and receive Medicaid benefits in a long-term care facility is going to depend on if you're married or single, first and foremost, because those amounts are going to be different. And if you are married, how much money you actually have is going to also dictate what you can actually keep. So if you're single, I'll go through a single person first because it's pretty straightforward for the most part. If you're single, they won't force that individual to sell their home, but they will place a lien on that home as they provide care. So Medicaid keeps a running tab of how much they've paid. They will attach a lien to that primary residence, and eventually that's where they get the equity from it. They don't force that person to sell it, but they will recover against it after they pass away at the very least. With other assets, you can have a prepaid funeral insurance policy. It has to be irrevocably assigned to your funeral. So when we're talking about that, it's usually in the neighborhood of about $15,000 per person. You can keep a car of any value. They don't care how much the car is worth. Then the other assets the individual has, you can keep life insurance if the face value of all the life insurance policies total is below $1,500. If you're over that, which obviously most people are, $1,500 is not a lot for life insurance, then they look at any cash value as an asset too. So with that single person, then they look at all the other assets that they have that are not off the table. So, things like that car, the life insurance under that value, or the funeral policy. And then they say, of that amount, you're only allowed to keep $2,000 of total assets. So that is a single person. The single person, all of their income, except for $45 a month, has to go towards their cost of care to supplement Medicaid. So they only get to keep an income $45 a month. So obviously that's not a lot, right? And that's where the biggest issue comes in. Even if you are on Medicaid and Medicaid is now paying for the care, how do you pay for anything that Medicaid isn't going to cover? Which there are things Medicaid does not cover. They're not going to pay for you to get your hair cut. They're not going to pay for you to go out to eat. Or if you like to just, maybe you like your Netflix subscription, something like that, right? And it brings you joy to watch all the Netflix shows, things like that. I mean, it can be little quality of life things. Medicaid's not going to pay for that. So a married couple, though, the calculations are a little different. If one spouse is at home, still is healthy, quote unquote healthy, not living in the facility, and the other spouse is the one receiving care, the healthy spouse gets to keep the home, their primary residence, with no lien on it. They get to keep any of their qualified retirement accounts. So things like 401ks, IRAs, 403bs, any of those types of retirement accounts. The accounts like that in the healthy spouse's name are unavailable for the other spouse's care. So those are protected in that sense. Then the same sort of thing applies with the life insurance. It's the same amount, that $1,500 face value. The funeral trust is the same, the prepaid funeral policy, and the car. And then when they look at all the other assets, so again, bank accounts, regardless of whose name they're in or if they're joint or individual, it doesn't matter. Non-qualified investment accounts, so like if you just have a brokerage account, other pieces of real estate, all of the other assets, the spouse who's in care, even their retirement accounts are available. So you add all of that value up, and then Medicaid says we're going to divide that in half. How much of that you get to keep, how much of that half you get to keep depends on how much it actually is. So the lowest they can force someone down to as a married couple is $50,000 for the healthy spouse. So if they're below $50,000 already, they may already be qualified for Medicaid. The most that anyone gets to keep of that half is currently about $137,000. So if you have more than that as your half, if it's 150,000 or if it's 300,000, you don't get to keep that half. You get to keep at most 137 roughly. I mean, it's not to the dollar exact. If you fall somewhere in that range, that's what that individual gets to keep. So if you only have $200,000 and that in half is 100, that 100 is what that person is keeping. And again, that's not counting their other unavailable assets like the home and the retirement accounts of the healthy spouse. So it may be more than that total, but of the other assets, that's what you get to keep. So Medicaid, and I should mention too, for the healthy spouse, they get to keep all of their income. And if they do not have income above about $2,800 a month, they can keep enough of the spouse in care's income to bring them up to that, potentially all of it, if it's still not enough, right? So the healthy spouse gets to keep all of their income, and if they don't have enough to get to that point, enough to get them up to about $2,800 at the most. So if the spouse in care is making $5,000 a month through various means, and the spouse at home is getting $800, they may be able to keep $2,000 of that spouse in care's income, but not the entire $5,000, right? So that's how Medicaid works. But the issue that people run into a lot is the spend down and losing the assets to the cost of care because of how expensive it is. And that can still be a concern for a lot of people. Another program that we deal with occasionally, a little bit less so in terms of, than Medicaid, just because of the population we're dealing with, is the Improved Pension Program through the VA. So this is a pension benefit for wartime veterans or the surviving spouses of wartime veterans. How they define a wartime veteran, by the way, is there's set dates that you had to have served. And you had to have served for 90 days at least of active duty, so not for training. It couldn't have been in the reserves either, so it has to have been actual active duty. National Guard often doesn't qualify unless they were activated and in that process. But it doesn't matter if they were over in the theater of combat or not, as long as they were active duty during a wartime period. As long as one of those 90 days of service, active duty, was during the wartime period, that's all that's necessary to qualify. So if I served the last day of World War II was my first day, and then the other 89 were after that, I still would be a World War II veteran according to the VA. And the other kind of qualification is you can't have been dishonorably discharged. The veteran couldn't have been. So with that, though, how that pension benefit works is sort of like Medicaid. They tried to somewhat keep the same calculations in some ways, but they also are different enough where the rules are quite different overall. So this is a direct pension benefit to the wartime veteran or the spouse of the wartime veteran, the surviving spouse. But you have to, it's based off of that the veteran's income or the surviving spouse's income. So the pension benefit, it varies the amount that person is going to get depending on whether they are married and the veteran is the one receiving that income, a single veteran, or the surviving spouse of the wartime veteran. It's kind of in that tier. So a married wartime veteran is going to get the most. The surviving wartime veteran who is single will get sort of a middle amount between those two, and a surviving spouse would get the least benefit. But how that works is they look at the veteran's income or their surviving spouse's income, and then they deduct that from the total benefit. So if you have more income than the max benefit, that veteran won't get anything. However, once that veteran needs care, they deduct the cost of care from their income. So it can help this benefit, then they can receive all of it potentially if that's how expensive their care is. It can help privately pay for care a lot longer than that somebody otherwise would have been able to do. Just like Medicaid, they have some qualifications for assets as well. So that's where I was saying they tried to use somewhat of the same numbers, but they used a little bit different calculations. Whether you're married or single for this program actually doesn't matter in terms of what the veteran or the spouse gets to keep. They don't count the primary residence as an available asset at all. So it's not counted towards the total that this veteran is able to have. And up to 2 acres of land directly surrounding the home. If it's more than that in terms of land, they may count that extra land as an asset, depending on like how large a lot has to be saleable in that local like zoning laws, honestly. Then, unlike Medicaid, they have no other protected assets, no other assets that don't count towards their total that they're allowed to keep. But the total that both a single veteran and a married veteran gets to keep is about $137,000 as well. But no other exemptions other than that primary residence and the 2 acres of land around it. So it's a little bit different than Medicaid there. Better for a single person, but not actually better for like a married couple in terms of what is unavailable, right? So Medicaid has a 5-year look back. That's where people talk about that 5-year rule. What that essentially means is if you gifted something away, or if you sold the asset for $1 and it was worth $1 million, right? The difference between that sale is a gift. Or if you tried to protect money from your cost of care and it was something that you otherwise would have been able to spend on your care. If you did that within the 5 years before your Medicaid application or 3 years for the VA application, then they will give you a penalty for it. That penalty is not, for example, you must pay us back. It's not we're going to go in and take more from you. It's a time penalty that they won't provide that assistance. So Medicaid bases it off of, they have a number they divide it by. It's roughly about $9,300 is their divisor. So what that means is if somebody gave away $93,000, or it's 9,300, excuse me. So if somebody gave away $93,000 before they went into a facility and it was within 5 years of that Medicaid application, that would be a 10-month period of time that Medicaid would say, we're not going to help you. You have to find a way to pay privately through that. So you have to be very careful about making gifts if you're trying to protect it from care, or if you think you might need care within that period of time. With gifting too, a very common question we get is, well, I thought there was an amount you could give and it wasn't a problem, per year. The issue with that is what most people are referring to there is the gift tax exclusion amount, which is currently $16,000 per person per year. The issue with that, though, is that's the IRS regulations. That's the IRS rules. That is not what Medicaid says you can do. So you can't gift any amount of money for Medicaid. You have to be very careful about that because a lot of people create issues for themselves thinking that they're getting around these rules by making these gifts, but then actually, unknowingly creating a big problem for themselves. So there is no amount of money you can gift penalty-free for Medicaid. And even with the gift tax exclusion, it's not really a tax most people are going to have to pay if they go over that. It's just tied to your end of life exemption, which is currently $12.06 million per person. So most of us don't have that issue, myself included. So the VA, their 3-year look back period is very similar. If you gave money away that you otherwise helped you get qualified for the VA benefit, then it's a penalty as well. They have a slightly different divisor, so it's not quite the same, as Medicaid there, but you have to be very careful is what I'm trying to get at with the gifting and, what you're doing to plan for care. So one of the biggest things when you're planning for care, as I mentioned, is not just making it through that private pay period is definitely important. But once somebody is on Medicaid, because they don't get more than $45 a month personally, if they're the one in need of care, that can create a big issue for, like I said, those other quality of life things that they maybe are looking for in terms of, like enjoying life still, right? Medicaid does pay for a lot, but it doesn't pay for everything. And it's not going to pay for, the quality of life things like I want to go out to eat with my friends or, go bowling or, whatever it might be, but it's just things that are not related to care, specifically anyway. So how do we pay for that, right? I mean, once you're spent down, where does that money come from? How is somebody able to do that? So that's often where people try to gift things. That's where they're trying to get things out of their name so that somebody has that money protected and can do that. The issue that people unfortunately run into a lot is, and I'll use the home as a primary example here, is they will gift the home over to the kids. They'll put the home in the kid's name. We get questions about that a lot, of whether that's a really good idea. If you can avoid it, it's a very good idea to avoid doing that. There's really three big issues with gifting the home or putting the home in the kids' names. One, we talk about control as a really big factor in elder law planning, a lot of maintaining as much decision-making control and control over assets, control in general over our life choices as possible, right? We all fear that loss of control as we get older because there's some loss of independence. Some of that's natural, right? But we want to hold on to it as much as we can. That's why sometimes, like, whether or not mom and dad should be driving still is a big topic of contention, right? So with that control as a main goal, the number one way to lose control over something entirely is to have someone else own it, right? Put it in the control of someone else. So the issue with gifting to the kids might be if the kids start charging mom and dad rent, or they sell the property or evict mom and dad. In theory, they can legally do all of those things now, and you don't maybe want them to be able to do those things. I hope your kids wouldn't do that to you, but it's something they legally could, and it's a big risk, right? So, I mean, obviously, with any sort of planning you're doing, you want to make sure you trust the people that you're involving, but it is definitely something you don't want to create as an opportunity for someone to do harm. But even if that's not your concern, there's two other reasons not to put the home in the kid's name. First is it's really bad tax planning. So when you have what's called a cost basis in your home, which is essentially a very watered down definition, is what did you pay for it, right? What did you buy for when you buy the home for? What did you pay to build it, right? And what do you have value-wise in the home? When you sell your property, any capital gains tax is assessed on the gain between what you have in the home in terms of cost basis and what the fair market value was when it's sold, or like what you actually sold it for. However, when you own your home and it's your primary residence, you get an exclusion from those capital gains of $250,000 per person. So a married couple, for example, would have $500,000, meaning if the gain is within $500,000, they're not going to pay tax on it. However, if you gift that over to the kids, you transfer your cost basis to them. That means the IRS says they're going to have the same cost basis you did. Basically, whatever you bought the home for or built the home for, that's what they did. If they're not the primary resident of the home, or it's not their primary residence, they can't get that same capital gains exclusion. So it means that if they then turn around and sell it, they may have to pay, depending on their own tax rate, 15 to 20% of that gain in taxes to the government. You can avoid having that be an issue if you leave the home to that individual through an estate plan, if it's part of your estate. When you pass away owning an asset like that, whether it's stock or real estate, that cost basis gets adjusted up to fair market value. So then when the kids turn around and sell it, there's very little to no gain at all on it. So passing those assets on is a much better tool than for tax planning than it is to gift. It's an issue that we run into quite a bit when we see people coming in with those types of plans already in place. The third reason, and probably the most important one to be aware of, is when somebody owns a property, right, their liabilities are the liability of that property. So when you gift the home over to your kids, maybe you make it out more than 5 years, and it's never a Medicaid issue for you. But what happens if one of your kids passes away? What happens if they get divorced, or there's a lawsuit, or they file for bankruptcy? Well, if any of those things happen to you, especially bankruptcy or like a lawsuit liability, there's legal protections for you over your primary residence. So, the goal there is that we don't have people filing for bankruptcy and then being homeless, right? And being out on the streets because they couldn't keep their home. So you have some protections from those things. However, when you gift it to the kids, and if it's not their primary residence, they don't have those same protections. So you may be protecting it from one liability on your end of long-term care just to open it up to other people's other liabilities. And it can be a really big risk because you never know when those things can come up. Even a very responsible person can be sued. People get sued for really stupid things all the time. And it doesn't mean that anybody will win, but it's a risk. And really, people passing away is a really big concern as well, because then your home goes in accordance with their estate plan. So do you want your in-law owning the property? Do you want your minor grandchildren technically owning the property, or potentially someone with like a substance abuse issue, right? Those can be very big concerns for people. So gifting the home is a really, or any asset for that matter, can be a very dangerous plan because it just doesn't protect against a lot of things. I mean, obviously, even if someone is very responsible, those things can come up. So what we tend to do to set money aside, what would be better than that plan would be to use a certain type of irrevocable trust potentially for that. And the reason it's better than gifting to the kids is it does a couple of things for you. For Medicaid purposes, you can't be your own trustee of that trust. So it still usually is the kids or somebody that you trust in that position. However, as part of that trust, you have an occupancy right that says they can't evict you or charge you rent or sell the property without your permission, as long as you continue to pay the property taxes and utility bills. So that sort of thing protects you from the, son or daughter evicting you or charging you rent type scenario. The other part of that trust is when you pass away, it still has the step up in cost basis for any capital gains issues, meaning it'll lessen or eliminate those taxes for the kids when they inherit it, assuming they sell it right away. So it's better for tax purposes as well. But really where it is the most useful is trustees don't own the trust. They're merely, I view them as almost like property managers, right? If you have ever rented an apartment, the property manager doesn't necessarily own the building. Maybe they're just managing it for the owner. So if that trustee then has any of those personal liabilities come up, like a divorce or a lawsuit or any of those things I mentioned, it doesn't happen to the trust itself. They do not own those assets. They're not available for those liabilities. So it's much safer to do it that way than it would be to gift it over to them, because you're not opening it up to their liabilities. Irrevocable trusts, still, you have to play with the 5-year look back rule, right? So it's still subject to that. It still technically constitutes a divestment for Medicaid, but it is a better plan if you're trying to do prospective planning than just putting it in the kid's name. The other thing that irrevocable trust can be used for, and one of the things I mentioned as a big concern for people, is the ability to supplement care later. And there's ways for that to help provide some ability to do that so that you don't have to spend down all the way. I'm a little over time here, so I don't want to keep you guys too long. But one last thing I'll mention to you is, because this is an issue I've seen actually come up relatively frequently over the last couple of months, and that's not normal necessarily, it's just happened a lot recently, is people will come in and ask if their life estate deed that they have is protected, or if that was a good idea. So life estate deeds prior to August of 2014, they used to be protected, wouldn't be available for that person's care, and it wasn't available for Medicaid to come in as a creditor of the estate and take that home away later either. If it was done after August of 2014, August 1st of 2014, then it's not protected from the estate recovery side of things anymore. So it's not, people are still doing these life estate deeds, unfortunately. The ones I've seen come in recently, it was like 2017 was a one. So unfortunately, people are thinking that they're better protected than they are with those. So don't panic necessarily if you've done one, if it was prior to August of 2014. But if it was done after that, you may want to have that looked at. I do see, what does it cost to do an irrevocable trust? It varies depending on the programs that we're dealing with, whether it's Medicaid or the VA or both, right? In general, it's anywhere between $6,800 and $8,400 to do an irrevocable trust plan. And that includes like all powers of attorney and retitling assets and doing all of that. It's all encompassing. We tend to do flat fees in our office for things like estate planning and elder law. one thing too is, or before I close out and let everyone go, is just to remind everybody that keep an eye out for the email where you'll get those forms from us, the handouts, and then also the feedback form. If you would like to come in for an initial consultation, remember that it is complimentary. So we usually schedule them for about 2 hours to get to know you. We ask for a lot of information so we can assess the situation as best as possible, but you don't pay to set up that initial consultation. And then just a reminder that our, and actually, what is our topic next week? I'll have to look at that. Our next topic next week, though, is we're going to do this the same time on Wednesday. So if you're interested in hearing us talk a little bit more about things, probate and settlement. Thank you. So probate and settlement is our topic for next week. So probate being, what happens if after you pass away and your will goes through probate, and how does that work for people, and what kind of things do you need to be aware of as potentially the executor or personal representative? And then settlement is more often referring to when somebody has like some type of trust, whether it's a revocable or irrevocable trust, doesn't really make a difference in that sense. It's just more of the alternative to probate if you have a trust. So we'll talk about that, and it's really helpful for especially someone to listen to if they are potentially the one taking care of that estate or will be the one taking care of that estate. Same time as this one was today on Wednesday next week. So please sign up if you're interested, and thanks.